subject to your lordship, so I was going to move on next to Article 6. The Article 6 point, as your lordships would have seen, arises by way of a respondent's notice, the learned judge having concluded that it didn't add anything to her conclusion about the principle of legality. And it being a respondent's point, I'm going to deal with it only in outline for the moment, and insofar as I need to deal with it in reply, come to it there. My Lord, the first point to make is that the Article 6 issue arises only if your lordships conclude that the legislation construed in the usual way, in accordance with English principles of statutory interpretation, does prohibit the entry of judgment for so long as sanctions are in force. And that is because the courts have consistently explained that where Article 6 issues arise, it is necessary first for the court to undertake, well, it's necessary for the court to undertake a two-stage process. The first stage of that process is to construe legislation in the usual way, by applying ordinary principles of statutory interpretation without reference to Article 6 or any other convention right. Once that is done, the court asks whether the legislation so construed is compatible with the convention. And the answer to that question depends not only on whether the legislation construed in the usual way, normal way, imposes a restriction on the relevant rights, but also on whether the restriction is justified, that is to say, is imposed for a legitimate purpose and is proportionate. And that is, of course, because it is not the bare fact of a restriction, but only where the restriction is not justified, that there is an infringement of the convention rights. Now, for your lordship's notes, Lord Sales, Mr. Sales as he was then, has extrajudicially emphasised the importance of the two-stage approach, citing relevant authority. Can I give your lordships a reference to that?
Is that the article?
It's the article in volume 16 for your lordships, tab 108, page 4986. It's internal page 608. Your lordships will see a reference in footnote 51 to a case called Popplewell. Footnote 51 is on page 4992. That is not in the bundle. When your lordships do go to, can I just mention that the reference is a slightly wrong reference. He cites, so far as we can tell, the wrong paragraphs of Popplewell. I think he refers to paragraph 75. In fact, it's paragraph 72 and 73. Sorry, pages 72 and 73. So that is the two-stage approach which your lordships should be conducted. And we only get...
Hang on a minute, wait, so that's footnote
51, Popplewell, which is not in your bundle. So
actually,
page 4992.
It's in the bundle. Where do we actually find it in the text of Lord Sales?
If you go to page 4987.
4987. Yeah, I see. In both cases, the approach is construction. Yeah. Okay, thank you.
So, as I was submitting yesterday, one only gets to this stage of the analysis if our construction of the regulations is correct as a matter of ordinary statutory interpretation, and you only get to the need to read down, read in, if your lordships, having done that first exercise, then ask or determine whether the restriction, if there is one, is imposed for legitimate purpose and is proportionate.
Yeah.
Now, so far as concerns the application of Article 6, we accept that a temporary stay on the ability to obtain judgment debts can in principle engage Article 6. There's a case in the bundles, I'm not going to take you to this, which is authority for this. It's a case called Kutich, K-U-T-I-C-H, volume 11, tab 54, page 3375. But a key difference between the right of access and Article 6 is that, as the Strasbourg Court has repeatedly said, Article 6 is not an absolute right. And indeed not really just a principle of interpretation, because it doesn't affect the interpretation. You have to read it down afterwards. Now, my lords, following on from that, and importantly, the European Court has already found that sanctions imposed by the EU following Russia's invasion of the Ukraine, which are of course virtually identical to the sanctions imposed by the UK, are lawful and do constitute a proportionate interference with certain fundamental rights protected by EU law. I should say at once, in relation to this point, that the case in which this was decided, the RT France case, which your lordships have in the bundles at volume 14, tab 92, page 4595, the reference is at 4617, paragraphs 165 to 167, and 4602, paragraphs 52 and 54. That case, the RT France case, was concerned with a different fundamental right, namely the right to freedom of expression. In our respectful submission, the direction of travel is clear. Sanctions are regarded as proportionate and legitimate, even if they infringe fundamental rights. Now, our second point that we make in relation to Article 6 is the so-called Bosphorus presumption. In the interest of time, I'm only going to deal with this in reply, but for your lordship's note, we address this fully in our skeleton argument below at paragraph 6, which is at supplemental bundle tab 14, page 268. Para 63, sorry. And the presumption, perhaps I can just show you, lordship, something just to save you time.
So this is a supplemental.
I'm going to show you an extract from Richard Gordon's book, which explains this more clearly than I can. If you go to volume 16 of your lordship's bundles, and you go to, in volume 16, tab 119, page 5214,
Yeah.
I should just say this is a text on sanctions law, the late Richard Gordon QC and Michael Smith QC, Tom Cornell, 5214, paragraph 8.29. Have that. The Bosphorus presumption is crucially important to the way in which the court examines sanctions imposed by international organizations. According to the Bosphorus presumption, where action is taken by a contracting party in compliance with legal obligations stemming from the membership of an international organization, such as the EU or the UN, the action is justified in the eyes of the court, provided that the relevant organization is considered to protect fundamental rights in a manner which can be considered at least equivalent to that for which the ECHR provides. Importantly, the presumption is rebuttable, which means that the court will review a case where it finds that the protection of rights was manifestly deficient, even where the presumption applies in principle. Unfortunately, the court has refrained from elaborating on the meaning of manifestly deficient, and there's yet to be a case where the Bosphorus presumption was found to apply, but nevertheless rebutted on the facts. And the point, just standing back, is if you're a member of the EU, there is a presumption that your membership of the EU, you will abide by. The EU won't require you to do anything which is inconsistent with human rights. If the EU requires you, passes a regulation imposing sanctions, there is a presumption again that that is not going to have infringed any fundamental rights. Now, it works if you're a member of the EU. We're obviously not a member of the EU anymore, but our regulation, as your lordship knows, tracks not exactly, but almost exactly the EU regulation. So we are in a situation where the Bosphorus presumption, at least by analogy, would apply. Now, what is clear from the Kutic case, my lord, is that although Article 6 does apply in relation to delays, it's not any delay. that will give rise to an Article 6 infringement. The delay has to be such as to, since go over a reasonable, rational, proportionate limit. An authority for that is cutage. Now, a point we make about that is that, so far as it would apply to this case, if there was an Article 6 right which was involved, notwithstanding the points I've made, since the time for that would not be now, it would be at a point in time at which the court concluded that the stay had been in place for so long it was no longer reasonable to maintain the stay. One doesn't infringe Article 6 simply by imposing a stay. One infringes Article 6 by imposing a stay for an unreasonable period of time. And that again presupposes that there has been a breach of Article 6, that's to say that whatever you're doing is not proportionate and legitimate. Well, that was all I was proposing to say about Article 6 at this stage. Can I move on, again subject to the court, to the question again raised by my learned friend's respondent's notice, which is whether the court is a person for the purposes of regulations 11 to 15. Now, my learned friends appear to put the point in two ways. They say first that as a matter of construction, the High Court and apparently private arbitrators are not persons within the meaning of regulations 11 to 15. And that, for your lordship's note, is paragraphs 52 to 59 of their skeleton, page 109. And they say secondly, which as I understand their skeleton, is a point which arises only if their first point is wrong, is that the High Court, although not arbitrators, form part of the Crown, and that there is a presumption that the legislation does not apply to the Crown, even if, as a matter of language, the High Court is a person. And that, again, for your lordship's note, is at paragraphs 60 to 64. I'm not entirely sure that these are separate questions, but I'm going to deal with them separately just because it may be convenient to do so. Can I deal first with the point of construction? We submit that there are three reasons why my learned friends are wrong about this, and indeed why, as we submit, the point was certainly not accepted by the judge and is inconsistent with a paragraph of a decision, and I'm not relying on that. It's a point which your lordships need to decide, in a sense, decide afresh. The first point we make about this is that there is no linguistic basis for my learned friend's contention that the court is not a person. The word person is defined in very wide and inclusive terms in section 9, subparagraph 5 of the 2018 Act. Can we just turn that up? It's at tab 11, which I think is in volume 3 of your lordship's bundles. Tab 11, page 777, 3 sevens. In this Act, if your lordships have it, section 9, subparagraph 5, in this Act, person includes, in addition to an individual and a body person's corporate or unincorporate, any organisation and any association or combination of persons. Now,
do you say it is any of those, or do you say it's just called it's inclusive?
I would say it's, insofar as you're not talking about an individual judge, it's not any of those, but it is in the inclusive.
And are we talking about an individual judge? If Mrs Justice X gave judgment, would she be personally guilty of the crime, or personally the person?
She's not going to be personally guilty of anything, for reasons I'm going to come on to.
All right, but would she be the person who had breached the sanctions?
she would be a person who has breached the sanctions.
In a personal capacity.
Well, my lord, not in a personal capacity, because she is sitting as a judge. But it doesn't say it has to be in a particular capacity or other. She is plainly a person. I should make it clear, I don't depend on establishing that she is an individual person. But in my respectful submission, this doesn't say in one particular capacity or another.
No, I understand that, which is why, because you introduced this by saying it's the High Court, which is a person.
Fair enough.
Now, if what you're suggesting is it's the judge who gives judgment, then I think there's probably no doubt that they're an individual and within the definition. But are you saying that?
Well, I'm saying both, actually. I'm running both arguments.
Right.
And certainly we say that there is no linguistic basis for excluding the judge as a person, or the High Court not as a defined person there, but as being included from this provision. Certainly my learned friends don't explain why the court is not a person, or why an individual judge is not a person as a matter of ordinary language.
So just so I've got it clear, the person is either the judge, in which case it's clearly within the definition as an individual, or it's the High Court as an, let's use the word entity for as a neutral term,
Indeed.
which you don't contend falls within any of the identified categories, but it's only an inclusive definition.
Indeed.
If I understood correctly.
You have. Now, I will also just note, under my first point, that the European Court has said, in a case called Mollendorf, Mollendorf, that the German land registry was a person for the purposes of the EU regulations, which were in materially identical terms. The contrary was not even argued. For your Lordship's notes, Mollendorf is at volume 11, tab 58, page 3482. The relevant passages are in particular paragraphs 51 and 52 of the judgment of the court, page 3510 to 3511. And my lords, we would respectfully submit that it is hard to see why, if the land registry is a person, a court or a judge is not. That is our first point.
Do we get person in the EU regulation anyway?
We'll check that, my lord. Check that.
I'm not sure we do, which is why I don't want to make it go to the authority. But,
I understand why you're saying.
I'm just
we'll come back to that, my lord,
intrigued
because
by exactly what the authority says if we're not dealing with person.
it doesn't. I don't think it says person. I don't recall there being a definition in the court deciding a land registry is a person. It just rather assumes the land registry is caught by sanctions and is not allowed to do what it did, which is to register an entry in the land registry.
Thank you.
Could you just remind me where Mollendorf is? I might just
Volume 11. Perhaps I can take it. The only reason I'm rushing through this is I'm conscious of time, and I apologise because it's not the right way to do this. Can I just show your lordships the passage maps? It's in volume 11 for your lordships, tab 58. So it starts at 3482. The relevant paragraphs begin at page 3510.
Yeah. It's really dealing with made available, isn't it?
Which matters for our purposes, obviously, my lord.
Yeah.
So I'm not saying that this is conclusive, binding, or anything like that. All I think both sides can do is to refer to points which move one way or the other, subject to one paragraph which I'm going to take you to later.
Well, speaking for myself, I don't think those paragraphs support the proposition you've put to us.
Well,
I don't think they're dealing with whether the land registry is a person at all, because paragraph 51 is focusing on the designated person, I think, because it's saying a person is effective, under the applicable national, person is effective to obtain full power of disposal in relation to the property. It's making the point that the act of the land registry in final registration makes available
But that's my point.
funds or whatever.
That's my point.
It's not saying the land registry is a person, because the EU regulation doesn't actually frame it in that way, I don't think.
With respect, the land registry is making something available. A land registry is not allowed to make it available. In this case, the court is making it available. If we're right about the way in which the definition works, the court is making it available.
I mean, I follow the argument, but as my lord was indicating, there is a structural difference between our regulations and the EU regulation, because here the court is concerned with Article 2.2, which simply says no economic resources should be made available without any reference to person. It's only in the regulations that person comes in.
There are structural differences, but I go back to what I've called the continuity point,
Yes.
which I'll come back to again in spades, if I can put it that way, in relation to this issue. Because if my learned friends are right, I'll come to it, but if my learned friends are right, there has been a very material change, no continuity at all in relation to this particular issue. I'll develop that in a moment. And Mollendorf, in a way, is one indication of that. Anyway, so my first point is about the definition of person and whether my learned friends have found any linguistic basis for saying that the individual judge, the court, falls outside of it. The second point that we make, my lords, is that my learned friends' approach would give rise, we respectfully submit, to an anomalous distinction between courts and arbitrators. Because, my lords, whatever may be the position in relation to the High Court or to a judge, there is, we would respectfully submit, no possible linguistic basis for suggesting that private arbitrators do not constitute persons as defined in the regulations.
And again, is that on the basis of an individual or three individuals, or is it on the basis of they collectively coming within one of those descriptions in
They are
9.5?
individuals, three individuals. They do their job as individuals who contract to do their job as individuals. They're appointed as arbitrators, but they're appointed as individuals as arbitrators, pursuant to a contract to which they are personally and individually parties.
Right. And do you say that the tribunal, if I can use that expression to describe them collectively, comes within any of the identified categories in 9.5, or again, would you say that at a tribunal it's only an inclusive definition and therefore they also are swept up?
Just looking at my lord,
Well, you could say
any association or combination of persons. It would be a very odd thing if persons can, by association with someone else and by giving themselves a name or a capacity, avoid the consequences of these provisions. So, one way or the other, in my respectful submission, individual arbitrators are caught, and there is no linguistic basis on which arbitrators who act as individuals can fall outside these provisions.
Okay.
Now, my lords, if we are right about what we say about arbitrators, that they are persons, it would mean that if my learned friends are right to say that the court is not a person, judges are not people, persons, an arbitral award in favour of a designated person would be unlawful on the basis that arbitrators are caught. Whereas a court judgment on the identical causes of action with exactly the same result, giving money to claimants, would be lawful. And my lords, it appears to be one of the very few things about which the parties at least are agreed, which is that that would not be a rational distinction for a sanctions regime to draw. it would either permit both or prohibit both. And that shows, we submit, that it cannot be right to treat the court as exempt from the regulations. Now, I ought to say, I'm not going to take up time now. My learned friends do dispute whether arbitrators are court, but they do it by a bootstraps argument. And you may say I'm deploying exactly the same technique. They say, well, court is plainly not a person, therefore arbitrators can't be a person, because it would be irrational for one to be court and the other not. We said exactly the other way around, with, in my respectful submission, a much better basis in the language of the statute. Arbitrators plainly are court. It would be very odd for the court not to be court.
Yeah.
So that is our second point. Our third point, and again, this is not conclusive in any way, is that there are at least two authority, one in this court, which recognize or at least assume, proceed on the basis that the regulations apply to the court in its judicial capacity. The first of those authorities is R&R, which is a decision by this court which your lordships should have at volume 14, tab 83, page 4351. Perhaps I can just summarize the facts in this way. Case concerned a Mr. Rottenberg, the appellant in that case, who had been sanctioned under EU Regulation 269/2014, so the old EU regulation. That had been implemented in the UK by regulation, the Ukraine European Union Financial Sanctions number 2 regulation 2014. I'm going to refer to the implementing regulation as the 2014 UK regulation. The issue in R&R was whether the English court could order Mr. Rottenberg, the sanctioned person, to pay maintenance to his wife and children by way of a payment from a Russian bank account into a Russian bank account. So Mr. Rottenberg had been made the subject of a court order obliging him to pay maintenance to his wife and children from a Russian bank account to another Russian bank account. And that is the order which had been made in this jurisdiction by Mr. Justice Moore in the Family Division. Now, in the Court of Appeal, Lord Panic for Mr. Rottenberg had argued that such an order could not be made because if the order had provided for payment in England, it would be unlawful without a license, and providing for payment in Russia excuse me, would amount to circumventing the regulations, which was an offence under Article 9 of the EU regulation, which corresponded to Article 10.2 of the UK regulation. Now, my lords, the particular regulation which Lord Panic was arguing had been contravened was Article 10.2 of the 2014 regulations. That was expressed to be applicable to conduct by a person. And one sees that, for example, if your lordships go to page 4362, bottom right-hand corner of this table, which sees Article 10.1. A person who contravenes any of the prohibitions commits an offence. A person commits an offence who intentionally participates in activities, etc., and then A, to circumvent any of the prohibitions in regulations 3 to 7. So it's the offence is by a person who circumvents the provisions. Now, of course, my lords, if, as my learned friends contend, the court does not constitute a person, and Mr. Rottenberg's appeal was obviously untransparently hopeless and could not have got off the ground because the court could simply have said, we're not a person, we can't therefore contravene Article 10.2, which only applies to a person who seeks to circumvent. And therefore this appeal, that what Mr. Justice Moore did is a falls within 10.2 is obviously wrong.
Would Mrs Rottenberg not have been engaging in conduct in seeking such an order?
Well, she may have been as well. She may have been as well. I don't know. That's not the point that was being taken. The point that was being taken was that the court couldn't do this. If your lordships look at paragraph 1 of the judgment, this appeal raises a short but important point of law about whether the court can make an order for payment by a husband. If the court is not a person, then plainly it could. There'd be nothing to stop it. And so if the court was a person, that's the way in which the appeal would have been dismissed. But, my lord, it is plain that that isn't the view that the court formed. On the contrary,
Just developing your point, if you go to paragraph 15, I think what you're saying is the clearer.
I'm grateful, my lord.
Because it says in the suggestion is that the court is participating in the circumvention.
Indeed. So it was very much about whether the court was doing something it couldn't do. And that presupposed that the court was a person for the purpose of Article 10.2. Now, Mr. Rottenberg's appeal failed anyway, but for other reasons. And the Court of Appeal expressly envisaged the possibility that the court could contravene the regulations while acting in its judicial capacity, which, as your lordships will appreciate, is possible only if the court is a person for the purposes of the regulations. Can I just show your lordships? I've shown your lordships paragraph 1. This appeal raises a short but important point of law about whether the court can make an order for a payment by a husband in favour of a wife. And my Lord Justice Newey has pointed to paragraph 15. If your lordships then can look at paragraph 29, page 4359. Picking up the first two sentences, it follows that the making of a court order would only circumvent the EU regulation for the purposes of Article 9 if the order itself contained provisions which dealt with funds or economic resources and which were also intended to achieve a dealing with funds or economic resources within the scope of the EU regulation without the license of the Treasury. The order in this case contains no such provisions since it does not require any particular funds of the husband to be used for discharging it. But my Lord, the first sentence explains what type of court order would amount to a contravention of the regulations. The second sentence explains why the order made by Mr. Justice Moore in that case was not an order of that type. My Lords, the importance of the first sentence is that it necessarily means that the court was thought to be a person for the purposes of Article 10.2 of the 2014 UK regulation. Otherwise, Lady Justice Arden could not have said what she did in the first sentence. So, my lords, that is R and R. I should just make the point now that it's obviously a different case to this because it was about making an order against a designated person. Whereas here we're talking about making an order in favour of a designated person. And a lot of the reasoning, in a sense, concerns the against rather than in favour. But it doesn't concern the particular point that I'm making. Now, there is another authority, but not one in this jurisdiction, that we identify in our skeleton argument, and that is the Taruta case. It's a decision in the BVI by Mr. Justice Jack, and as I mentioned to your lordships yesterday, that decision was overruled by the Eastern Caribbean Court of Appeal. Mr. Justice Jack's decision is only understandable on the basis that he too considered a court to be a person. He's overruled by the Court of Appeal, but not on that point. The Court of Appeal in that case also proceed on the assumption. Now, I'm not saying that there was detailed consideration of this at all. So I'm not saying there is a binding precedent either in R and R, or indeed that you find reasoning in Taruta that helps. But it is, we respectfully submit, at the very least, interesting that in these cases there has been no issue about whether the court is a person. And both of those cases, can I just give you the references to root? I'm sorry. At first instance, it's paragraph 34 in the judgment of Mr. Justice Jack. It's volume 11, tab 52, page 3279. And in the judgment of the Eastern Caribbean Court of Appeal, volume 15, tab 101, page 4836 to 37, it's paragraphs 74 and 76. Now, my learned friends also make 2 points in the skeleton argument, which if I can just pick up. They say, as your lordships will have seen, that it could not have been intended that the High Court is exposed to criminal financial penalties, and they say it could also not have been intended that it is subject to the licensing regime. I've seen that in their notes, skeleton at paragraphs 54 to 55, page 109. Can I just take the licensing point first? The premise of this point is that there would be any reason why OFSI would ever wish to grant a license to the courts to in effect give money to a sanctioned person. And my learned friends don't explain how or why that might arise, nor what licensing ground might be relevant here. And I would suggest it is plain, and indeed common ground, that there is no such licensing ground. So it's not clear what the premise of the example is. So this point goes nowhere. Were my learned friends imaginatively to find some scenario in which this might become relevant, the short answer to that is that the application need not be made by the court. It could be made by the person seeking to benefit from any such payment. Just as in this particular case, the license is sought by Steptoe, even though the payment is to be made by the claimants. As for the criminal liability point, my lords, which is at least more interesting, there is a simple answer to this point, and that is to be found in section 52.2 of the 2018 Act. That provision, which I'm going to take your lordships to in a moment, states expressly that the Crown cannot be made criminally liable under the regulations, even if it is bound by them. I'll come to that in a moment if I can. So my lords, just on the interpretation point, we submit the court is not exempt from the regulations. This is a matter of interpretation, and it plainly cannot do something that is prohibited under the regulation. And if I'm right about that, then regulations 11 to 15 do apply to the court. But even if I'm wrong about that, and even if your lordships decide that the court is not a person, it is, as your lordships will appreciate, not an answer to our point under regulation 11, namely that there would be a dealing by the claimants if judgments were to be entered in their favour, such that the entry of judgment is unlawful, even if the court is not a person. Now, just on that, yesterday, in the context of the Regulation 11 argument, we've reflected on a point made by my Lord, or put to me by my Lord Justice Newey yesterday, which I ought to say something about. That's transcript, I'm not inviting you to turn it up, transcript day 1, page 60, lines 2 to page 61, lines 13. The question my Lord asked was whether, on our case, the claimant breaches Regulation 11 subparagraph 4 before judgment is entered. The answer, my lords, we respectfully submit, is that it does not. But it does not follow from that, we submit, that there is a dealing under Regulation 11.4 only by the court and not the claimant. And perhaps I can just unpack that a little bit. The reason why the entry of judgment constitutes a dealing in the underlying cause of action is either that the cause of action is altered or extinguished, or that its value increases or decreases once judgment is entered. The lordships will recall that from yesterday. And it is true that the act of actually entering judgment is an act of the court rather than that of the claimant. But my lords, under Regulation 11 subparagraph 4, if a person participates in a process which culminates in an event that alters or destroys funds or changes their character or value, that person has dealt in funds under Regulation 11.4 once the event happens, not before. And so even if, and that is so even if someone else needed to do something for that event to happen. There is no rule that Regulation 11.4 applies only to purely unilateral acts by the person. That is to say, acts which do not require anyone else to do anything. And perhaps I can just give an example to illustrate that. Suppose that a designated person is the beneficiary of a debt obligation or a guarantee, which, as your lordships will have seen, are funds rather than economic resources, as they are expressly classified as such in section 60 subparagraph 1 of the 2018 Act. Now, my lords, if the designated person enters into an assignment or settlement agreement in respect of that debt obligation or guarantee, there is a dealing in funds, namely the debt obligation or the guarantee, once the agreement is entered into. That is because its value or character will have changed depending on what the agreement says. Of course, that is not a purely unilateral act. The designated person could not have entered into the settlement or assignment agreement without the consent of his counterparty. But it could not be suggested, we would submit, that the mere fact that the counterparty's consent is required means that there is a dealing only by the counterparty and not by the designated person. Once the counterparty gives his consent and the agreement is entered into, there is a dealing, not before. But at that stage, it is a dealing by both parties, not merely the counterparty. And what we respectfully submit that example demonstrates is that participation in a process which culminates in an event that changes the value or character of a fund constitutes a dealing once the event happens, not before. And applying that to our case, we've always accepted that issuing a claim is not prohibited, nor is participation in litigation. It is the entry of judgment that is prohibited. So there is no dealing until judgment is entered. But once judgment is entered, it is a dealing not merely by the court, but also by the parties who participated in the process that culminated in that event. Just as the designated person in the example I gave participated in a process that culminated in the settlement or assignment agreement.
Can I briefly ask you one point, which isn't really directly tied to that, but tied to other things you've said? You talk about a change in value. Why is a change in value relevant? Because that's not one of the things that's identified in terms in Regulation 11. It says change in volume, amount, location, ownership, possession, character, or destination. It isn't a change in amount.
Possession. Your Lordship is right. I do say value. In our respectful submission, it would come within amount or character. Yeah. Sorry, I should have used less loose language than that. My Lord, just going back to the is a court a person point generally. I've dealt with the point as a matter of interpretation. I need next to deal with the closely related point about whether there is a presumption against Crown application which is engaged, and whether it is right to say, as my learned friends must, that has not been rebutted either by express language or necessary implication. Now, we obviously accept that there is a presumption against Crown application which is engaged unless you can show that there is express language or by necessary implication that the presumption should not apply, and that must apply to the 2018 Act as well. And just taking this in stages, if I may, we accept, of course, that there is a presumption that the Crown is not bound by legislation unless expressly or by implication it binds the Crown. That is obviously not an immunity from liability, but it's a rule of statutory interpretation. And that's how it was put by the Supreme Court in the R against Black. Just to give your lordships a reference, that's volume 13, tab 70, page 4065, paragraphs 36 sub 1 and 36 sub 2. And if your lordships can also look at paragraph 37. Now, as we understand it, my lords, my learned friends say that this presumption matters because even if the court constitutes a person as a matter of language, the presumption applies such that the regulations do not, after all, apply to the court. Whether it's a two-stage process or a one-stage process doesn't really matter, but we entirely accept that one needs to do the exercise. We say, my lords, that my learned friends are wrong about this because the presumption is rebutted either by express words or by necessary implication, and or both. There are three related reasons why we say this. First is this. If, as my learned friends contend, the regulations do not apply to the Crown, then the law in this area has changed dramatically after Brexit. In order to explain why that is so, I need first to show your lordships what the position was under the EU Russian sanctions regime pre-Brexit. Your lordships will recall Regulation 2692/2014. That was implemented in the UK by UK regulations also of 2014. Can I just invite your lordships to look at those? They're in volume 7, behind tab 30, page 2094. So it should be tab 20, I think. I think I may have said 30. Volume 7, tab 20, page 2094. Looking at the first page of that, just looking at the introductory text on 2094. The Treasury are designated for the purpose of Section 2.2 of the European Communities Act 1972 in relation to restrictive measures against persons and bodies listed by an international organisation. These regulations make provision for a purpose mentioned in Section 2.2 of that Act, and it appears to the Treasury that it is expedient for any reference to, you then see a reference to the EU regulations concerning restrictive measures in respect of actions undermining or threatening the territorial integrity, sovereignty and independence of the Ukraine to be construed as a reference to that annex as amended from time to time. The Treasury, in exercise of its powers under Section 2.2 and Section 2 of the European Communities Act, makes the following regulations. I can then invite your lordship just to glance at regulations 3 to 7 on page 2096. Lordships will see language which your lordships will now be becoming very familiar. Reflect the provisions we've seen at regulations 11, 12, and 14. Your lordships then go on to page 2100, regulation 17. Let's read this to your lordships. The Crown is the heading. These regulations bind the Crown. Sub 1. Sub 2. No contravention by the Crown of a provision of these regulations makes the Crown criminally liable. And then 4, nothing in the regulation affects Her Majesty's. Your lordship sees the rest of it. But it's really subparagraphs 1 and 2. They bind the Crown is not criminally liable. So under the EU Russian sanctions, the Crown was bound. But under 17.2, the Crown was not to be made criminally liable. And your lordships will recall that when I was addressing the learned friend's suggestion, what do we do about judges committing crimes, I referred your lordship to section 52.2. I'm going to come on to that. But this is how things stood before Brexit.
Was there a definition of person in these regulations? I only ask because my eye lit upon regulation 1.2, top of page 2095, which seemed to be identifying who commits a criminal offence, which is quite limited. Doesn't seem to be the criminal liability doesn't seem to be attached to persons.
No, your lordship is right, but I'm not sure that matters because that is in respect of offences committed wholly or partly outside of the United Kingdom. So in a sense, that's an extraterritorial provision.
Yes, I see it, and we'll find the criminal liability within the individual regulation.
Exactly.
Absolutely.
So I'm not sure that that makes a difference. I don't see a definition of person there, but presumably it's the Interpretation Act, the definition of person which applies, which is very broad. In fact, if anything broader, it also says persons includes the following.
I think it's rather narrower than 9.5. I think, doesn't the Interpretation Act say individuals or body corporate or unincorporate, which and then in 9.5 we've got that plus organisations, associations and so on. Okay, doesn't it?
Anyway, it doesn't have it in here, but your lordship see the point about regulation 17.1, the Crown is bound, and regulation 17.2, no contravention, makes the Crown criminally liable. And we respectfully submit that if it would be surprising if under the EU sanctions as applied by the UK regulations implementing the EU regulation, the Crown was bound, yet under the post-Brexit sanctions, the Crown was no longer bound, which is Malone and Friends' contention. Malone and Friends have identified no reason whatever why that would be so. Indeed, it's completely contrary to the continuity arrangement on which they so depend. If they're right about continuity in all respects, then they have no answer to this with respect. That is the first of our points.
I mean, I suppose as a supplemental point, the 2014 regulations must have been intended to marry up with the EU regulation.
Indeed.
So it won't have been perceived to produce something different at the time.
Now, the second point we have arises from section 52, subparagraph 1 of the 2018 Act, which is in volume 3, tab 11, page 811.
Volume 3.
Tab 11, page 811. This is SAMA, so it's the act with which your lordships are now more familiar. Just looking at section 52, Crown applications, regulations under section 1 or 49 may make provision binding the Crown. And then 2, the regulations may not provide for the Crown to be criminally liable. Now, the provision, the section 52.1 may not be a model of clarity, may make provision binding the Crown. In our respectful submission, that we say means that it is open to the executive to make any provision that in fact binds the Crown. The executive is not obliged to do so. It could choose, for example, not to bind the Crown in relation to a particular provision, hence the word may.
You needn't think that they would automatically bind the Crown, because is there an equivalent to Article 17?
This is the closest you get. This is the closest you get.
Well, that's the point.
I understand that.
What this is contemplating is that any regulations that are made can include a provision like Article 17.
Well,
It's
in our
not
respect for-
saying you're automatically covered, as it were.
In our respect for submission, it goes further than that. It says you may make provision binding the Crown. Whether or not you've done so is a matter of interpretation.
Yep.
You need to look at the provisions to decide whether they have made provisions which bind the Crown. But what this is doing is rebutting the presumption that the provisions which are made under that regulation do not bind the Crown. So in a sense, all it's doing, I'm not saying this tells you the Crown is bound.
No.
Whether the Crown is bound or not depends on your Lordship's interpretation of the language. But what this is doing is rebutting the presumption against Crown application. That's as far as we say this goes. And if your Lordships want to know whether the provisions made do bind the Crown, well, you've got the language of the provisions, and in particular person. You've got the inconsistency with arbitrators, and you have the continuity point. You have nothing in the provisions which suggests the Crown will not be bound. So we don't say that this is the equivalent of Regulation 17, but it is sufficient, we say, to rebut the presumption, especially when you interpret it against the backdrop of the European regulations.
Is it the case that for this to make a seamless whole on your case, you have to treat an individual judge or the court service as the Crown? Because otherwise they could be criminally liable.
Indeed.
So you need to say, well, if you've got a judge, you've got the court, they're all emanations of the Crown, but they're not criminally liable because you can't make the Crown criminally liable.
Indeed. That's a fair point, my lord, and it's a point we've grappled with, because you could argue that in modern terminology, that the Crown used in statutes is intended to bind the executive, not the judiciary, and there are cases which suggest that. They are not entirely clear or particularly helpful. It's pretty clear that this is, we say, however, intended to include the Crown. I mean, you get very odd results if it doesn't include the court. If the Crown is not bound, let me put it that way. I mean, one point is this. Why should, if this doesn't bind the Crown, leave aside the courts, what about government ministers? Are they allowed to send money in some official capacity to Russia? Are they allowed to do whatever they like on the basis that sanctions just don't apply to them? Is anyone who can say they are, for present purposes, to be regarded as the Crown, in effect free from any of the impositions of the sanctions regulation? That is the consequence of my learned friend's interpretation. He has to, against his own interpretation, start drawing distinctions between who the Crown applies to and who doesn't. And I should note that my learned friend's case is to accept that judges are the Crown. That's in their skeleton in paragraph 61. So we say section 52(1) doesn't bind, it's not of itself binding the Crown, it's effectively rebutting the presumption. It's saying the presumption against Crown application doesn't apply in relation to this. You can decide for yourself as a matter of interpretation, but on any basis, no criminal liability. And just in terms of why, since we have moved from Regulation 17, which has something saying the Crown is bound, to why here it's simply rebutting the presumption. To some extent, I've touched on this already. The regulations are made under Section 2. Sorry, the authority to make the regulations that we just looked at, the 2014 UK regulations, arise from Section 2 of the European Communities Act. that says nothing about the Crown being bound, not bound, anything like that. And so the work of saying whether the Crown is bound and they're not going to be criminally liable is something that you had to do in the regulations themselves because there was no statute which covered that.
Does the presumption apply to delegated legislation as well as primary legislation? If the primary legislation says you may by delegated legislation make the Crown, bind the Crown or make the Crown criminally liable, does the presumption then still apply to that delegated legislation, so that there's a presumption that the delegated legislation does not do so unless it does so expressly or by necessary implication?
If that's a point in my favour, I agree with it. If it's a point against me, then I don't agree with it. But I'm not sure I entirely. I think I understand.
It's my fault. I think in this context it would be this. You say look at section 52.
Yeah.
That is sufficient in itself to rebut the presumption, irrespective of whether the regulations do or don't.
Okay.
And therefore you approach the regulations without the benefit of the presumption, as I understand
That's
it.
it. Yeah.
But if the presumption applies to legislation generally, and therefore can apply to both delegated and primary legislation, then might it be said that if the primary legislation says we're going to leave it up to delegated legislation to indicate whether the Crown is or isn't bound, does the presumption not then apply to the delegated legislation to see whether it has expressly or by necessary implication bound the Crown?
My Lord.
Have I made the point?
No, I understand what your Lordship's saying. Your Lordship is saying it's okay to, since rebut the presumption in the primary legislation, which says someone who's delegated to make legislation, but that same presumption arises in relation to the delegated legislation.
No, I'm not quite saying that. I'm saying you don't rebut the presumption by passing the legislation on, if I can put it that way. You can legislate by primary legislation or by delegated legislation. If you do it by delegated legislation, then the mere fact that the primary legislation says it is in the delegated legislation that you will find the legislative decision doesn't mean that the primary legislation is itself rebutting the presumption. I think that's the point I'm trying to articulate. It may well be wrong, but
I think it's the same point as I was putting to you a little while ago
I
about
understand
does
the point.
section 52 really, does it follow the regulations, as it were, in some sort of automatic way bind the Crown, or do you have to look at the regulations and in looking at them the presumption still applies? In other words, it has to be express or by necessary
understand the point.
implication.
All I can say in response to that is that the purpose of this was, as you see, to say you can make regulations binding on the Crown, and that the express purpose of that was to say when you make those express regulations, there isn't a presumption against it binding the Crown, because we said you can make regulations binding the Crown. Now, you can choose to make regulations which are not binding on the Crown, again, by saying so. But there isn't, I'm not sure I can put the point in any other different way. All we say this does is to rebut the presumption, so that when you read the regulations, you decide for yourself, having regard to the language there, whether or not the Crown is intended to be bound.
thank you.
My Lords, the second, the further point we make about this, as I say, I've sought to explain why it was done in this way in the statute, whereas under the regulations, it had to be done in the regulations, in Regulation 17, as it turns out, because there was nothing in the European Communities Act which dealt with whether the Crown would or wouldn't be bound or might be bound. We also say this, that if, as my learned friends contend, the Crown is not bound, then odd distinctions that we submit Parliament could not have intended would arise. To some extent, this is a point about necessary implication. For one thing, if the regulations do not bind the Crown, a distinction would arise between the courts on the one hand and arbitrators on the other. Already made that point. The learned friends do not suggest there is any distinction between the two. In addition, the suggestion that the 2018 Act doesn't bind the Crown would mean, for example, that government ministers and civil servants would be free to send money, make available, deal with President Putin or any other designated person, even though nobody else could do so. And that, I would respectfully submit, would plainly frustrate the purpose of the legislation, which is to deprive designated persons of all conceivable resources. Which is why we say that Parliament has either expressly in section 52(1) or by necessary implication made the 2018 Act and the regulations binding on the Crown. Now, my learned friends, I think overnight, have put into the bundle an authority. I'm not going to take it to you, my learned friend can take it to you if you want, called BBC and Johns. And so far as we can tell, they cite that for the proposition that general words, such as any person, do not normally include the Crown. I'm going to let my learned friend develop that, but there is obviously no blanket rule applicable to all statutes. Sometimes the words any person do not include the Crown, and sometimes they do, because the presumption against Crown application is rebutted, either expressly or by necessary implication. We have put into your Lordship's bundles a case, it's in the supplemental bundle, a case called Madras Electric Supply. It's at tab 7, the supplemental bundle. That was a case about a company selling its business to the Madras government, which it was common ground was an emanation of the Crown. And the issue was, in that case, whether the seller company was liable to certain balancing charges under the Income Tax Act 1918. That depended.
So this was the facts dated back to pre-independence, pre-India being independent. Is that?
That's right.
Yeah.
26. And the resolution of the question whether the seller company was liable to those balancing charges under the Income Tax Act 1918 depended upon whether the words any person in Rule 11.2, Schedule D to the Act included the Crown. The Lordship can see that if you go to internal page 680, 6.2. First paragraph. The point in issue in this appeal is therefore whether the purchase of the Government of Madras, being for this purpose a branch of the Crown, was a person within the meaning of Rule 11.2 of the contention of the appellant company being that neither the Crown nor any person exercising the functions of the Crown is a person within the meaning of the rule. So there is no person succeeded to the undertaking of the company. The Privy Council held that the Crown was indeed covered by the words a person in Rule 11.2 and that the presumption against Crown application was rebutted by necessary implication. Your Lordships can see that, page 685.
It's actually the House of Lords.
House of Lords, I'm so sorry, overnight.
That's why I asked you the question, because I was puzzled as to why a case involving Madras Electric Supply Corporation was in the House of Lords, and the answer is because it all dates back to 1947. So 6.8.
So if you go to 197 of the bundle, it's page 685.
Yeah.
My Lords, I consider the appellants to be right in this particular matter. Whatever ideas may have once prevailed on the subject, it is in my opinion today impossible to uphold the view that the Crown can find the prerogative and immunity from tax. The statute in question, according to its true construction, includes the Crown amongst those made liable to the tax it imposes. The appropriate rule, as I understand it, is that in an act of Parliament, general word shall not bind the Crown to its prejudice, unless by express provision or necessary implication. The Lordship see the word to its prejudice. That, however, is and has long been regarded as a rule of construction, and such being its nature, its application to the charging provisions of paragraph 1 of Schedule D seem to me to make an end of the respondent's submission in this respect. In that paragraph, the word person is a general word capable of including the Crown, but there's no express provision, nothing by way of necessary implication to make it include the Crown. And so as a matter of construction, it must be read in accordance with the rule as excluding the Crown. The question then is whether the word is to receive a similar construction in Rule 11.2, or whether it is there used in a less restricted sense and so to include the Crown. It's exactly the same word, a person. The presumption that the same word is used in the same sense throughout the same enactment acknowledges the virtues of an orderly and consistent use of language, but it must yield to the requirements of the context. And it is perhaps at its weakest when the word in question is of a kind that readily draws its precise import, its range of meanings from its immediate setting, or the nature of the subject with regard to which it is employed. In the present instance, it seems to me that paragraph 1 and Rule 2 of Schedule D are so different in their subject that the purpose of the word person must be given a different connotation in each. Paragraph 1 is intended to impose a tax, and in conformity with the rule of construction I've mentioned, the Crown is not bound, because if it were, it would be by its inclusion to its prejudice in the general word person. Rule 2, on the other hand, is not intended to impose a tax or to do anything prejudicial to any of the persons to whom it refers. It may work now one way and now another, but its object is not to add to the liabilities of the taxpayer, but to provide for terminal computations in the case of a trade changing hands. It does not purport to tax those who were not taxable before. I'm unable to see how its provisions can prejudice the Crown so as to justify its exclusion from the word person as used therein. Moreover, to exclude the Crown would be to ignore and run counter to the natural meaning of 11 to its obvious purpose. Your Lordships see the end. So I refer your Lordships to this really to show that the word person may include Crown or may not include a Crown, and whether or not it does really depends on context, the purpose of the statute, and factors such as that.
Can I just try setting one other hair running? So far as I know, the Ukraine sanctions have no UN basis, but some sanctions do. The Iran sanctions certainly had a UN basis, and I assume they still do. And that was the backdrop to the ModSAF issue. It would be very, very strange whether, in the context of UN sanctions, to say that the government could do what it liked. So if you found regulations in the context of a UN backdrop, which were in the same terms as these regulations, you'd think that there the government surely would be bound.
Indeed.
I don't know whether that would cast any light on how you interpret these regulations where there isn't a UN backdrop.
My Lord, with respect, that is very helpful, but it does go to the purpose. The whole point of these sanctions, as I think I certainly said to the learned judge at first instance, but also I think to your Lordships, from 1999, when you had international sanctions regimes, the language was the same. The purpose was the same, to deny all assets in any way. It's carried through into the EU regulations, and in our respectful submissions, it's carried through into SAMLA and the regulations made thereunder. What possible purpose would there be in circumstances where the Crown had always been bound, the government had always been bound, suddenly to depart from that? How does that serve sanctions purpose, which is to deny any possible recourse to assets to sanctioned persons? Well, the point of these provisions is not to detriment the Crown or anyone else. It's to act to the prejudice of sanctioned people. Of course, it restricts persons from doing something, but it restricts them not to prejudice them. It's to prejudice someone else, namely the sanctioned person. And in my respectful submission, it is an error to see this, to see my argument as in some way, I don't know, hostile to the court, hostile to. It's never good to be saying to a court, you can't do this, you can't do that. I know from experience it's not easy because, quite understandably, no one wants to be told what they can't do. And I appreciate that. But the purpose here is simply to find a regime which is coherent in denying sanctioned people money. And there is no doubt, it's beyond dispute, that if a judgment debt is made available to a critti, you have given them money, or at least the equivalent of money. And one question to ask is why? Why should government ministers or anyone else be special? Why should they have a free pass when it comes to giving money to sanctioned persons?
Okay.
I saw Al Qaeda regs also have a UN basis, I'm told by way of a note. Tab 9, page 730, just for your lordship's information.
Was that a convenient moment to have a break, Mr.
I have literally a concluding submission on the court as a person. If you give me 1 minute, I'll finish. And then so my lords, we respectfully submit that the 2019 regulations do bind the Crown. Otherwise, the consequences would be surprising in the way I've described, and there would be a strange and unexplained departure from the position which pertained while the EU sanctions were in force, leading to a strange and unexplained exemption that would enable ministers and emanations of the Crown to send money to Russia. I've made that point, and that all seems improbable. And if we're right about this, that is the end of the court is not a person point. And it's also an answer to the points about whether the court can be made criminally liable and the like.
Yeah.
So we say there's nothing in the point, but even if there is, your lordships have my point about Regulation 11, which this wouldn't affect.
Right. Have a break.
Sorry, no, I see, no, I see. Because
and also conversations with terrorists in different parts of some.
yeah, okay, no, I see. If it, yes, if the it's just that one.
My Lords, can I turn finally, before I leave ground one, of leaving the court as a person point, I'm moving on to deal with another topic which concerns the two sets of workarounds, as I think it is fair to describe them, identified by my learned friends, if, as we contend, your lordships were to find that the entry of a judgment debt would be unlawful. In that event, my learned friends propose two sets of workarounds. The first is that the court can, the learned friends say, enter what they describe as a conditional judgment in favour of a designated person, conditional upon him ceasing to be a designated person, or they say the court can order a judgment to be the subject of an immediate stay on enforcement, or they say the court can extract undertakings for the judgment creditor as to what it will do with the judgment. And that is the first set of workarounds for your lordships note, paragraph 65 of their skeleton. The second set of workarounds, which for your lordships note is at paragraph 67 of their skeleton, involve, they suggest, the court still conducting a trial and following that issuing, as they put it, a reasoned judgment without any accompanying order. And your lordships may recall that the learned judge rejected these workarounds on the basis that they are either ineffective or would undermine the sanctions regime, which on this hypothesis does prohibit the entry of a money judgment. Now that's a paragraph 133 of the judgment. I'm not inviting your lordships to turn that up, page 174. So this is another respondent's notice point. I'm going to take this shortly, largely for reasons of time, and I'd like to let the learned friends develop the point. But perhaps I can just identify the reasons why we say all of these workarounds are flawed. First, some or all of the workarounds will infringe Regulation 19. The lordships will find Regulation 19 at volume 4 of your bundles, tab 16, at page 928. It's similar to the Article 10.2 that we saw in the R&R case. Have it, page 928. A person must not intentionally participate in activities known that the object or effect of them is to circumvent any of the prohibitions in regulations 11 to 18b, or to b, to enable or facilitate the contravention of any such prohibition. And obviously, my lords, the assumption at this stage of the analysis is that a money judgment would infringe regulations 11 or 12. And it is also to be assumed that the sole purpose of giving a reasoned judgment or declaratory relief is to avoid what would otherwise be an infringement of Regulation 11 or 12. And that we would respectfully submit would fall within Regulation 19.1a, because it would be an activity whose object or effect is to circumvent Regulations 11 and 12. Secondly,
if a declaratory judgment doesn't actually infringe Regulations 11 or 12,
a declaratory judgment would not infringe. Well, it might actually, for reasons I'll come on to. It might, because you would be affecting. You wouldn't be making available funds,
no,
but you would be affecting the character of the causes of action, because you would effectively. So it would infringe.
yeah, you'd be doing that throughout the proceeding.
Yeah, exactly.
Every time the judge opens his mouth at any interlocutory hearing and says, "Well, I don't think that's a very good argument," which occasionally happens in the commercial court. Perhaps not so often in the Chancery Division, but it certainly does in the commercial court. The judge will be potentially changing the value of the cause of action, because, and we all know, at least some of us, you do, and we can still remember that, after court every day, there's a discussion as to, what the state of the case is, what the percentage chance of success is.
What is the judge
changing the value of the cause of action?
Exactly. Abandoned ship now. Indeed, my lord. So these workarounds with respect to, don't work. A declaratory judgment wouldn't work. A declaratory judgment actually is just not consistent with what is being asked for. They're asking for damages, and if one gave a declaratory judgment, even if it didn't itself contravene, it would A, not be what they asked, and B, plainly be with a view to trying to avoid giving them the damages judgment they asked, which would be a circumvention. Secondly, the problem with the first set of workarounds conditional judgment debt or a judgment debt with a stay of execution or undertaking given by the claimant, is that such an order would still be a judgment debt. It is simply a judgment debt that is payable in the future rather than immediately. And my lords, if we are right that the entry of judgment is unlawful, which is the hypothesis at this stage of the analysis, then the entry of this conditional judgment would be just as unlawful. So this workaround with respect doesn't work. The other workarounds identified in paragraph 65 are all flawed for the same reason, and I'm afraid don't have time to go into that. The third point we made in relation to this is this: if the court cannot, as a matter of English common law, the court cannot, as a matter of English common law, issue a reasoned judgment without any order at all, which is Malone and Friends' second set of workarounds. Indeed, if the court were to embark on that novel exercise, this would produce a result that would be fundamentally unfair either to the claimants or the defendants, because whoever is aggrieved by the reasons given by the court would have no right of appeal. Indeed, the Court of Appeal would have no jurisdiction to entertain an appeal, because, of course, appeals are against orders, not reasons. So these workarounds with respect do not work. Finally, my lords, one workaround which Malone and Friends haven't identified, but the Chancellor, my Lord the Chancellor raised it, is declaratory judgments. I'm not proposing to say any more about it, other than to make the point again that this is a damages claim. But for the sanctions regime, it is inconceivable that the court would grant a bare declaration, because doing so would not serve any purpose. The court would either dismiss the claim if it is not a good claim, or award damages if it is. And so declaratory judgment, again, the sole purpose of that would be to circumvent, and in my respectful submission, in any event, would contravene Regulation 11. That's all I was going to say about the workarounds, as I say, because I'm somewhat pressed for time. Can I, having dealt with that, leave ground 1 finally and move on to grounds 2 to 4 and 7, which is the off-sea licensing point. Now, as your lordships will be aware, there are 4 other acts in addition to entering judgment that fall to be considered. The parties are agreed that if you enter judgment, there is no licensing ground which relates to that. You can't get a license to facilitate the entry of judgment. But there are 4 other acts which are identified, which are also relevant to how this litigation might be affected by sanctions. The first is the payment of adverse costs. The second is provision for security for costs, and I can say immediately that that's, in a sense, goes with payment of adverse costs. The third is the payment of damages on a cross undertaking. And the fourth is the payment of a favourable costs order. The parties are agreed that in the absence of a licence from these acts are all illegal under the 2018 Act and the 2019 Act. So you cannot do these acts without getting a licence. And the issue, therefore, that arises at this stage is whether OFSI has power to license any of these. So I'm just turning first to adverse costs, which is ground 2. For your lordship's note, we deal with this in paragraph 76 and following of our skeleton, page 67. The learned judge held that OFSI does have the power to license a payment in respect of adverse costs, and that power exists under Schedule 5, paragraph 3. Just for your lordship's note, I'll take you to 5, paragraph 3 in a moment. The reasoning here is between paragraphs 163 to 181 of the judgment, tab 8, page 179. I'll come to that in a moment if I can. Can I first just invite your lordships to look at the provision, volume 4, tab 16, page 1255. All in Schedule 5.
Yeah.
And these are identifying matters in respect of OFSI has the power to grant a license. And subparagraph 5, Schedule 5, paragraph 3, to enable the payment of reasonable professional fees for the provision of legal services or the reasonable expenses associated with the provision of legal services. The issue between the parties is whether, when it talks about the payment of reasonable professional fees, it's your own fees, or whether that extends to paying the adverse fees, that's to say the fees of the other party. And to some extent, and I'll come back and develop that in a moment. While we have this opening, can I invite your lordships also to look at paragraph 6 of Schedule 5, page 1256. To enable, so this is another area where they can license, to enable by the use of a designated person's frozen funds or economic resources, the implementation or satisfaction in whole or in part of a judicial, administrative or arbitral decision or lien, provided that A, the funds or economic resources so used are the subject of the decision or lien, and B, the decision or lien was made or established before the date on which the person became a designated person, and number 2 is enforceable in the United Kingdom, and C, the use of the frozen funds does not directly or indirectly benefit any other designated person. Now, that is directly addressing pre-existing judicial decisions, and your lordships see that this allows for a license in respect of enabling the satisfaction and implementation of, among other things, a judicial decision or court order, but only in respect of a decision that was made before the date on which a person became a designated person. Now, Lords, plainly we submit that temporal requirement was included for a reason. If one asks why did the draftsman include it, there is only one possible answer, which is that the draftsman wished to confine OFCE's ability to license the satisfaction of court orders, implementation of court orders, to court orders made prior to designation. That's the purpose of B(1). And if, to the contrary, the draftsman's intention was that the funds of a designated person could be used to satisfy court orders made after designation, and not just prior to designation, there would have been no point in including that temporal requirement. In other words, it is, we submit, implicit in paragraph 6 that OFCE has the power to license the use of a designated person's funds to satisfy a judicial or arbitral decision made prior to designation, but that it does not have the power to license the use of a designated person's funds to satisfy a judicial or arbitral decision made after designation. Now, my lords, if I can then just invite your lordships to go to paragraph 172 of the judgment. So that's at page 180. The learned judge had regard to Schedule 5, paragraph 6 in the context of dealing with adverse costs. And your lordship see that at paragraph 172, the learned judge says this. I should perhaps add that my greatest hesitation here was caused by Schedule 5, paragraph 6, pre-existing judicial decisions, which I deal below in the context of favourable cost orders. However, while it was suggested that an adverse cost order was a judgment debt, the argument before me was not conducted by reference to this paragraph. In any event, I have concluded, again see further below, that the drafters of that paragraph did not have costs orders in mind and should not be taken to think of a costs order as a judgment debt. Now, in our respectful submission, the learned judge, although identifying the fact that this plainly has relevance to whether you can make a costs order, an adverse costs order, in relation to a post-designation judgment, since puts it aside on the basis that in Schedule 5, paragraph 6, the draftsman was not concerned with cost orders, orders made by court in respect of costs. And in our respectful submission, in this respect, the learned judge erred. Your Lordships will note, just going back to paragraph 6 of Schedule 5, that it says that it applies to judicial decisions. And in our respectful submission, there is no basis, certainly in the language, to exclude from judicial decisions a judicial decision awarding costs or a cost order.
Would that work? Let's just postulate a situation where the designated person fails to pay his own solicitor's fees, and the solicitor then obtains a court order for payment of the fees. On your case, that would be excluded.
Except that that is expressly allowed. Your Lordship,
It's not, because on this hypothesis, it's a court order.
a court
In your
order.
case, is that paragraph 3 enables payment, for example, voluntary payment by the designated person to his own lawyers, but not payment to the other side's lawyers.
Your Lordship,
And
that is right.
I'm simply
Yeah.
postulating whether the logical consequence of your argument is that you can't, if there's a dispute about the costs, then the solicitor can't get them.
That's true. That's right.
Your Lordship is right.
I think it must follow.
No, it must follow.
Very odd, isn't it?
These provisions are not entirely clearly drafted. That they do produce rather odd outcomes.
So it might suggest that that paragraph 6 wasn't, as the judge found, wasn't intended to encompass cost orders. Anyway,
Absolutely.
Maybe said they're cumulative, as it were.
They are
They're not mutually
permissions
exclusive.
rather than prohibitions. Yeah, I see that. So that is a point that we make about that, and I take what your Lordship say about that. In terms of the language of paragraph, Schedule 5, paragraph 3, can I just invite your Lordships to look at our skeleton between paragraphs 81 and 85, rather than developing that now. So it's at page 71, sorry, 69 to 71. Can I invite your Lordships to read that? It's there, I'm not going to add to it.
right, should we just read through it again
If your
just to
Lordships
remind
want.
ourselves?
Can I just, I'm grateful, my lords. Can I just go back to my Lord the Chancellor's oddity point about paragraph 5, 6? Sorry, Schedule 5, paragraph 6, and just have a go at this. The example my Lord postulates is as to whether the effect of this would be to stop the designated person paying his own solicitor's costs. But with respect, that would not be implicated in this paragraph, because this paragraph is all about the payments being made consequent upon a judicial decision. In other words, you wouldn't have a judicial decision that a person pay their own solicitor's costs.
And I think that was my lord's hypothesis, that he didn't pay them voluntarily, and his own solicitor said, well, I'll have to sue you for the costs, and got a court order.
But that,
I think that was the hypothesis.
For example, there's a solicitor and own client assessment, and the cost judge says you're liable to pay X to your solicitor.
but again, my lord, it may well be that that is in a way tough. That may be the consequence of that. But if you take the chance and you act for a designated person, and the designated person chooses not to pay their costs, then you have a problem. Which is why a lot of law firms are very careful about acting for designated persons. Can your lordships give me one minute, please?
Anyway,
I'm told that usually the license which a designated person is given, which enables them to pay their own solicitor's costs, will stipulate a date by which they have to pay those costs, so that you won't get this sort of problem. In other words, the license itself says you need to pay the costs by X. You won't need to get to the end of the litigation and come to the court and say I haven't been paid my costs, because the license will.
well, that's as maybe, but the designate. I mean, I follow this. It's all hypothetical, but sometimes cost orders are made. Or sometimes parties fall out with each other.
Yeah.
Anyway,
my lords, your lordships have my point. In
your
your
ultimate
respectful submission,
answer
it
is
is.
well just tough. That's what
It is.
That's what the
I'm afraid that
regulations
is
provide.
the answer. The learned judge gave some further. So those are our reasons relating to paragraph 3, which your lordship sees in our skeleton. The learned judge gave some further reasons outside the language of Schedule 5, paragraph 3, for rejecting our construction of that phrase, which I would just mention. The first, which your lordships will see at paragraph 168 of the judgment, that's page 180, is relates to paragraph 9M. 168, your lordship sees there's a reference to paragraphs 2, 5 and 9M, all specifically refer to the needs of and fees incurred by a designated person. I'm going to take this very quickly, simply to say this. When your lordships look at paragraph 9M, your lordships will see that it is introduced subsequently, that is to say after the rest of the regulation. And although it does, I think, specifically say, perhaps we ought to look at it so quickly, that's the point. Volume 4, tab 16, page 1259. Legal services to enable the payment of reasonable professional fees for the provision of legal services, and this says to the designated person. Reasonable expenses associated with the provision of fees to the designated person. This is about correspondent bank relationships. Now the learned judge drew from that, because that was specifically saying to the designated person, and you do not get in paragraph 3 the express language to the designated person. That was a point in favour of paragraph 3 not only relating to costs to the designated person. What we say about paragraph 9 is that it is irrelevant because, as my learned friends accept, it was introduced by amendment after the enactment of paragraph 3. And so it cannot have any bearing on what paragraph 3 meant when it was enacted. And obviously that meaning can't change. Equally, one could argue they introduced those words then to make clear what they hoped was clear in paragraph 3 in any event. So it's hard to see why paragraph 3M helps. So far as concerns paragraphs 2 and 5, can I just show those to your lordships? They're at page 1254 and 1255. So paragraph 2 is dealing with basic needs. Your lordships see that it says to enable the basic needs of a designated person to be met. And again, the learned judge drew some comfort from the reference to a designated person there. And the same with paragraph 5 on page 1255.
Yep.
Dealing with extraordinary expenses to enable an extraordinary expense of a designated person to be made. Lord, those paragraphs are plainly concerned with very different things, basic needs and extraordinary expenses, and one can quite see why they include a reference to the designated person, but the fact that they refer to the basic needs and extraordinary expenses of a designated person doesn't mean we say that paragraph 3 was intended to apply to legal services provided to third parties. Now, the learned judge gave a second reason, which was that our interpretation of legal services, which would not extend paragraph 3 to apply to the payment of adverse costs, would, the learned judge suggested, cut across the designated person's right of access to the court. That was at paragraph 175 of their judgment, on page 181. It's not clear whether that was a reference to the common law principle of legality or to Article 6, but either way, with respect to the learned judge, we are, with respect, not talking here about the ability of a designated person to pay their own lawyers. So that is not in any way an inhibition on the right of access, because, my lords, the fact that OFSI cannot license the payment of adverse costs, we say, cannot of itself infringe any right of access to the courts.
Well, I think the point she's making is, isn't it, that the effect, if you're right,
Yep.
that the designated person can't get a license to pay an adverse costs order, there will come a time, maybe not the first time, but there may come a time at an interlocutory stage where the other party to the litigation, a fortiori where the other party is the defendant as opposed to the claimant, says, well, this is all very unfair. I've got 5 costs orders in my favour for £4.5 million. I can't enforce any of them because they can't get a licence. Please stay the litigation. And she's making the point that the effect of that is indirectly at least to prevent the claimant from having access to the court, because the claimant can't pay its own lawyers, however much it wants to.
And I accept that, and indeed that is precisely the basis for the present application. It's another one of our grounds. We say that even if you think you can,
but I mean that's the effect of
I
that is
understand.
the effect of what you're asking for.
that is right. And so we accept that it might have adverse procedural consequences that the designated person can't pay adverse costs because it exposes the designated person to a stay application. But with respect, that cannot change the meaning of the words legal services in paragraph 3. By way of a related point, my learned friends cite the case of PJSC, which is a European authority, in support of the proposition that paragraph 3 should be construed broadly. Consistently, they say, with effective access to justice. But again, in a sense, that case makes the point that I'm making. PJSC was a case about being able to pay your own solicitors' fees, the ability to pay your own lawyers. And there one can quite see, it might be said, that not allowing that would restrict access to courts. But we're not in that category, at least for the purpose of this argument. And we would also note this, my lords, that the reference to access to justice doesn't help my learned friends either if he's wrong about the legality principle. Because if he is, then this is to be construed in the usual way, without any presumptions. Indeed, we respectfully submit that this needs to be construed narrowly, because it is an exception. And since it comes from European regulations, which is aware of the approach to European regulations, which is that where you have an exception, that is to be construed narrowly. We put a case in the bundle, to which I can perhaps just give your lordships a reference. It's called EZZ, volume 13, tab 71, page 4077, paragraph 31. Now, the learned judge gave a third reason in relation to the adverse cost point, and that your lordships will see at paragraph 176. The learned judge says, nor can one see any rational reason aligned with the scheme of sanctions why a designated person should not be able to pay costs of litigation which is in existence. An adverse costs order does not benefit a designated person. On the contrary, it diminishes its assets. It might therefore be said to further rather than undermine the object and purpose of the regulations. And with respect to the learned, and in fact my learned friends make a similar point in paragraph 73 of this skeleton, with respect to the learned judge, this is not quite right. Contrary to what the learned judge seems to have thought in that sentence, it is of course very much not the object of the regulations to diminish the value of the designated person's assets. That is why sanctions are not expropriatory measures, but are rather temporary measures designed to freeze assets while sanctions are in force, thereby preventing both any increase or diminution in the assets, save to the extent permitted by the regulations. My Lord, there is a further point we make in relation to paragraph 3.5, and it is this. Where a person pays a costs order in respect of the other side's costs, what it is doing is paying the costs order. If your lordships look at the language of paragraph 3, this is to enable the payment of reasonable professional fees for the provision of legal services. What is being enabled by a court order, what is being paid when there's a court order is the court order. It's not the payment of reasonable professional fees, it's the payment of the court order. And that's an interpretation argument. But it does support our interpretation that when it's being talked about, reasonable professional fees are identified here. They're the professional fees of the designated person itself. Otherwise, you will not actually pay reasonable professional fees. You pay the court order. It would also run into this difficulty if it applied to the payment of a court order in respect of adverse costs. Those costs would most likely already have been paid by the adverse party to their solicitors. So those costs are not being enabled by, what is being enabled there is not the payment of reasonable professional fees, because that has been paid. What is being enabled is the payment of a costs order. Again, that's a related point, but it also goes to why we respectfully submit that the learned judge's interpretation was too wide and wrong. Now, in their skeleton, my learned friends seek to dismiss this point as a parochial English notion and a triumph over form over substance. We don't accept that this puts form over substance at all. For example, if this appeal were to succeed and your lordships were to order the claimants to pay our costs of the appeal, and the claimants were to do so, it would, we submit, be very odd to suggest that they are paying the fees of NEO law, or indeed the brief fees of counsel. Rather, they would be satisfying a judgment debt. So it's not just form, it is in fact substance. My lords, I think that was all I was going to say about the first ground, that's the second ground, ground 2, adverse costs. As I said, security for costs, which is ground 3, stands or falls with ground 2. Yeah. I think that's agreed between the parties, so I'm not going to say anything about that. I need then to deal with damages on the cross undertaking. And this, as I indicated earlier, raises the question about Office's power to license the payment of damages on the cross undertaking given by the claimants for the freezing orders or undertakings that they obtained. For your lordships note, we deal with this at paragraph 93 and following of our skeleton. And as we there note, my lords, the learned judge with respect correctly held that Schedule 5, Paragraph 3 doesn't apply to damages in respect of a breach of a cross undertaking. And this is not challenged by my learned friends. That's a paragraph 193. But what the learned judge did say applied here was paragraph 5, Schedule 5. Just so that your lordships have that.
Extraordinary expenses.
Extraordinary expenses. And so the learned judge said that the payment of damages in respect of adverse costs were extraordinary expenses.
If she's wrong about that, what, one of the things I'm struggling in understanding what the practical issue is here, because the reality is none of this arises until trial, judgment. You on this hypothesis, you succeed, and the judge finds that the freezing order ought never to have been granted. Then there's an issue about what, if any, damages should be recoverable on the cross undertaking, probably in about 10 years' time.
But until that happens, your lordship would have to proceed on the basis that despite an undertaking to pay damages in respect of adverse costs, the claimants cannot do that.
Well, that's as maybe, but I mean, one answer to your point on this, maybe, well, it's all, at the moment, this is all academic and theoretical, and the one thing you can't say is that the proceedings should be stayed because of this issue.
No, we can't. I accept that. We can't say that just because of this issue the proceedings should be stayed. But they have given an undertaking.
I understand the point, Mr.
Yeah,
Rubin,
but
I'm just trying to
it's not
understand
about.
where
It
where
goes to discharge of the freezing order, rather than a stay. It is fair to say that it operates on two levels. We identify, in addition to the ground one point, which is in a sense the big point here, can you give a judgment? There are also, we submit, other respects in which litigating against the designating party is made hazardous by the sanctions regulations and by the narrow limits of Ofsey's powers. So that, for example, if they couldn't pay our adverse costs and they couldn't pay damages in respect of a breach of the cross undertaking, we are subject at the moment to a freezing order, which is in a sense unprotected. If that is costing us, so you have this. It's not a good idea to have litigation going on against a designated person because of these hazards. But there is the further point about, is it right to keep in place the freezing order when, so far as one can tell, indefinitely perhaps, the damages in respect of the cross undertaking is worthless?
And that's the exercise of a discretion, which has to take into account, on the one hand, that you might lose, and or there might not be any damages, and or there might not be designated persons when it came to collect on them, even if you got that far.
It would have to take all
So
that
you-
into account.
And those aren't discretions which have been exercised by the judge in this case.
By the judge at first instance?
Yes.
With respect, I'm not sure that they are, because what the learned judge effectively says,
No, I'm suggesting they're not.
they are not, sorry, yeah. It's not an
I wasn't
exercise.
suggesting they had been.
No, indeed, they haven't been
And
exercised.
that was a precursor to asking you is, if one gets to that stage, indeed,
There's a
if one
discretion.
gets to the stage of you being right on any of these,
Yes. You have a discretion,
are
absolutely.
you inviting this court then to exercise its discretion, or
Indeed.
whether there should be a stay, stroke, release from the undertakings,
I-
or do you say it should go back to the judge?
I would invite this court to exercise its discretion.
On this aspect, if we got that far, there's the Pugachev case, isn't there?
Precisely. That's really, in a sense, our point here. The undertaking in respect of damages for the crossing undertaking is, in a sense, the price of the freezing order. And if that is worthless, then the price for the freezing order is not being paid. And if the price for the freezing order is not being paid, that is a compelling reason why the injunction, the freezing order, should not be. And that is the short point. I can take a long time with this, but I don't have it. But that's where it comes to.
Whether it's worthless depends on whether you're still designated when it comes to.
Well, but your lordship makes the point. Your lordship makes the point that it's an indefinite. You made the point earlier.
All I'm suggesting is these.
That?
I speaking for myself, I would have thought there are discretionary considerations which require the exercise of a discretion. It may well be to be exercised in your favour, and I was simply asking whether you're asking us to do that.
No, indeed. But in the context of that, and again, my Lord Justice Newey has identified our point. It is the Pugachev point, which is that it's very clear that undertaking in respect of damages in respect of the cross undertaking is the price you pay. If it's worthless, you're not paying a price. And then the question arises, should you maintain the injunction? And we respectfully, or the freezing order, we respectfully submit that you shouldn't, partly because sanctions are indefinite. But before I get to that, I have to show that the learned judge was wrong, and that damages in respect of a cross undertaking doesn't fall within the exceptional expenses, extraordinary expenses provision. And on that, the first point is this, I suppose. Your Lordships will have in mind my point about paragraph 6 about it would be slightly odd in circumstances where paragraph 6 says you cannot provide, you can't enable payment of a judicial decision, save where the decision was one making the person a designated person came into effect, save where the decision post-dated the person becoming a designated person, predated the court becoming a designated person. This would be
There might be a judicial decision in the future.
there might be, but whatever it is, it would be made after the date on which the person became a designated person. And although the learned judge, we've debated whether that includes court orders for costs, but we're not talking here about a court order for costs, we're talking here about damages. So if the learned judge is right about Schedule 5, Paragraph 5, it does cut across Paragraph 6. And it would be odd for one type of damages to be permitted to be payable after the date on which the person became a designated person, but not other types of damages, because I don't think it's suggested by anyone that there could be a payment of, for example, damages for breach of contract to a designated person, where that decision was made after the person became a designated person. So damages for cross-undertaking, okay, apparently. Damages for everything else, not okay, because of the effect of paragraph 6. Our respectful submission, that's unlikely to be correct. Now, that is leaving aside the language of paragraph 5 in any event. And in a way, this is a first impression. The question is, when one sees language about extraordinary expenses, is it right to treat damages in respect of a cross-undertaking as an extraordinary expense? In our respectful submission, it's not. This is not, it's supposed to be, I think the language is unanticipated, maybe it wasn't unanticipated by the person who gave the undertaking, but with respect, it's the sort, or courts awarding damages are the sort of things which arise all the time. Extraordinary expenses, we submit, are intended to have a narrow scope. That is reflected, I'm not going to take your Lordship's to it, in a policy note issued by the FCO in 2018, volume 16, tab 113, page 512. Perhaps I will show you, Lordships, that, because it's interesting, because it tells you what at least they thought this was about, for what that's worth. Volume 16, tab 113, page 5129.
You're asking us to look at that?
Can I, please? Sorry. I'm just going to invite you to paragraphs 14 and 15, page 5133, I think it is. Extraordinary expenses. EU legislation currently enables licenses to be issued for payments by designated persons that cannot be easily anticipated and are not recurring. We anticipate preserving the ability to do so in the future, however. For this licensing ground to apply, the transaction must be both extraordinary and an expense. This could be used in circumstances where there may be a foreign policy or humanitarian priority for the UK. which we may want to be able to respond flexibly, where no other licensing ground apply. We want to keep licensing grounds tightly focused to maximise the effectiveness of the asset freeze. So intend to set out parameters to avoid the possibility of this licensing ground becoming a catch-all, which is not the intention. Now, take that for what it's worth. But in our respect for submission, it does reflect what one would ordinarily understand the word extraordinary to mean, which is cannot be anticipated, out of the ordinary. And in our respect for submission, an award of damages in respect of a cross undertaking is not something which one can properly say cannot be anticipated. It is precisely what is anticipated when you make the order, or to give the undertaking that there should be damages if there is a if loss is suffered. So that's all I was proposing to say about that ground. Favourable cost orders is ground 7, and that's about whether OFSI has the power to license the payment of favourable cost orders, that is to say cost orders made against a third party in favour of a designated person. That would involve money being paid to a designated person. Now, my lords, I hope you'll forgive me if I just give you a note to our skeleton on this, rather than developing the point. A fair amount still to get through. That's at Core Bundle tab 4, page 73. It's paragraphs 99 and following. Can I then move on?
Just very briefly, why would that point help you?
That's why I'm not spending time. I mean, we may be right, we may be wrong, but it
But it's
doesn't
not a
help.
reason to
Your
stay
Lordship
or anything.
has put your finger on precisely why I don't want to take time on it. It
Yes.
arises from the learned judge's judgment. I think there was some historic issue why one of the defendants cared about that, but it's not really relevant to.
That's why it's ground 7.
It's ground 7 and it doesn't really affect the discretion. That it doesn't say litigation is hazardous or anything like that. It doesn't help us on that. Can I then move on to? I've still got to cover control, which is a large topic. But before I do, can I just deal with stay and discharge? I'm dealing with it. It doesn't really matter what order I deal with it, but I am going to deal with it by taking this first and then leaving hopefully most of the period after the break to deal with control and regulation 7. What this involves is dealing with the consequences that would follow if the sanctions points we have made is correct. Obviously, if I'm wrong about this, about those points, this issue doesn't arise. We respectfully submit that the judge should have granted a stay of these proceedings and should have discharged the undertakings given by my clients in lieu of the freezing order obtained by the claimants. I can deal first with a stay and then with a discharge.
Sorry to slow you down, but again, you say that's all a matter that we should decide.
I would
rather
invite
than
your
send back
lordships
to
to
the
do that.
judge, because
Your lordship
it does occur to me that some of the factors that might be relevant to it, such as how desirable it is to make findings now, how stale the evidence will be if you delay, all those sorts of points are not really matters on which we're very well informed.
My lord, if I can put it this way, I don't feel strongly about it. If your lordships feel the better course is to, if your lordships are with me and you feel the better course is to be, that this should be remitted to the judge, I'm not going to argue against that.
Well, I think I'm speaking for myself. I tend to agree with my lord. This raises issues which really are beyond the remit of this court.
Okay. Well, then that does save a bit of time. So if I don't then need to address your lordships on stay and discharge.
It'd be better to leave it. If we're with you on your points so far, then the matter will need to be remitted.
I'm grateful for that indication. So I think I can then deal with control rather than starting it at 521. Given that I'm not having to deal with it, I can either go back to favourable costs, or you can take your lordships can take an early lunch on the basis that.
Will we rise now and come back at 5 to 2?